Today's good question. Chanley asks, once someone is indicted on a charge, can the court later change the charge if the defendant does not take their deal? They say, for example, if someone is indicted for trafficking and is offered a deal for possession and diversion, and the defendant said, no, I don't want to take the possession, I want to fight the trafficking charge, can that charge later be changed to possession anyway? I asked defense attorney Abe Mashney about this. He told me that is a possible scenario, but it wouldn't necessarily be the court changing the charge. A jury could find someone guilty of a lesser offense, even if they were initially indicted for something more serious. Prosecutors could also instruct the jury on a lesser charge so that jury has options in case they don't think someone is guilty of the more serious charge, for example, drug possession instead of trafficking. But he told me that could go the other way, with prosecutors filing a superseding indictment to add additional charges if they feel the case warrants it. He said that might happen in persistent felony offender cases. And when in doubt, it's best to talk to your attorney. If you have a good question, you can email goodquestion@wkyt.com. I'll see you on WKYT Mornings.